So we're looking at child abduction today and what that actually means. And we're going to start with what is habitual residence, because every child has an habitual residence, which means that's where they live, that's where they go to school, that's where they go to the doctor, that's where they have their support network, and that's where they, spend time with their other parents. So habitual residence is important to understand, because we're then moving on to look at, well, what does that mean if a child is then taken to a country that's not its habitual residence and then arguably kept there, so retained there wrongfully, or a wrongful removal essentially. And the importance of that is then to understand, well, how can the children be protected? And they can be protected under for certain countries, what we understand and know to be the 1980 Hague Convention. And basically, the Hague Convention is an agreement between various different countries, over 100 signatories. And each of these countries who are signatories to the Hague Convention agree on how, what their requirements are for a child that's been essentially wrongfully retained or removed to a country within the Hague Convention, one of those signatories. Now, obviously, if the country isn't a signatory of the Hague Convention, there's a different set of rules. But if they are removed to a country that is a signatory to the Hague Convention, then there are limited defences to it, and usually, unless there's any reason why not, the child will then be returned back to their country of habitual residence. So, for example, if there was a child that we found in England that had come for a holiday, say with his father, and the father decided after the holiday that actually, he wanted to keep him here, he was enjoying it here, didn't want to go back, the mother in France, where the child is habitually resident, would be able to take some action through the Hague Convention, through the relevant authorities and channels, to get the child returned from England to France. And the defences to the Hague Convention are very limited. They are consent. Was the removal lawful? Did the other party consent to it or acquiesce to it when it happened? Was there a grave risk of harm if the child is returned? And then we're looking as to whether the child objects to a return. So I had a case some while ago where we were looking at a child who's objecting to the return, and given his age, the court took that into account and agreed that the child could actually remain here, even though England was not the child's country of habitual residence. The country of habitual residence was another signatory to the Hague Convention many, many miles away. So it works very effectively, and the defences can work in certain circumstances, but it's quite difficult to, and rightly so, it's quite difficult to defend a Hague case, which is why we're less concerned if a child has been removed or retained in a country that is a Hague Convention country. If we're dealing with a country that is not a Hague Convention country, there is still recourse that can be brought, and obviously we're talking about what recourse can be brought in the courts in the UK for a return of a child to a country that's not a Hague Convention country, such as India, for example. But obviously the process is more difficult because we haven't just got that agreement in place like we have with the Hague Convention. And so in that situation, what we do is we look at making an application in the High Court for a summary return under the court's inherent jurisdiction to the country that's not a Hague Convention country. And I had a case just like that very recently where two children were subject to proceedings in a non-Hague Convention country, and they'd been brought over to England wrongfully, without permission of their father. We were acting for the father, and were retained here, so wrongfully removed and wrongfully retained here in England by their mother. And so what we were able to do for the father was to bring proceedings in the High Court to seek a return of the children back to their country of habitual residence. And indeed the court, went through the process. Obviously we had various court hearings to look at what should happen to these children. But ultimately the court decided that they should be returned to their country of habitual residence. So it can be done. We get children returned all the time to countries that are not signatories from the Hague Convention. But when the country is a signatory to the Hague Convention, the process is very neatly set out and it's very clear to understand, and the defences are very limited.